Thank you, Mayor. And yes, Chief Anderson is on Zoom tonight to join in this presentation. As you know, the chief and I provided a pretty extensive overview of the concerns we had related to District Attorney Alonzo Payne at our last City Council meeting on March 2nd. Tonight, we are going to make that a little bit abbreviated, but some of it is going to be very much the same in case someone wasn't able to see that, so they can best understand what council is considering tonight. Additionally, we have information almost coming to us daily on other situations, and so we have incorporated some new information as well. For those who want to see that presentation from March 2nd or some of the documents that we are relying on, we have created a web page off of the city's website at cityofalamosa.org/DA-concerns/. That is where we are putting all of the information for the public to be able to view. So as we started the last meeting, we indicated that since the DA was sworn in on January 12th, 2021, that we had many concerns. We had concerns related to the professionalism of the office, the violations of the Victim Rights Act, the unprecedented use of sweetheart deals for very serious crimes, the lack of response in carrying out regular duties and simply communicating as a community partner, and really the important one for us, the risk to our law enforcement officers for every interaction they need to have with these emboldened criminals. However, as I indicated, we are getting information sent to us a lot, and this is something that's evolving. We have new concerns because of that. A new set of concerns we have is about retaliatory behavior and the abuse of power following the felony charges that the DA Payne has filed against former DA Willett. We also had to wonder how he has time to process that when he can't process our warrants. The second concern that we have is the lack of prosecution for animal cruelty cases that I will share some information on here in a bit. Similar to the last meeting, I want to make it clear that we made several attempts to meet with the district attorney in order to express our concerns and see if we could make some changes. Those efforts were fruitless, and he has made it clear that he does not believe jail is an appropriate consequence for any level of crime. We also shared with the district attorney that we have very similar philosophical beliefs when it comes to low-level offenses. We have started the LEAD program. We're getting ready to start the co-responder program. We have a long-standing diversion program, and City Council decriminalized many of the municipal court offenses. The areas we have a strong difference is on the higher level of offenses.
So I want to share with you a few samples of plea deals that highlight the threat to our community. Our police department has conducted over 40 narcotic operations in the past 9 months. Not one of these cases has resulted in a trial. They have all been dismissed or pled to less serious offenses with very minimal jail time. These operations include significant amounts of seized drugs, money, and weapons. Richard Newton, suspect. Officers made contact in a parking lot in Alamosa for an active warrant. Mr. Newton refused to exit his vehicle and accelerated, dragging a Colorado State Patrol trooper who was backing up one of my officers through the parking lot, causing injury to that state trooper. We are lucky it was not more serious. Under the plea deal, he received a deferred sentence. Mr. Newton received a deferred sentence for 36 months and 60 hours of community service. Trey Howell and April Barron's murder of a 16-month-old baby who had trauma to the brain due to being smashed into a bedroom door. Howell pled to accessory to crime and got 72 months deferred sentence with terms and conditions of probation. Barron's pled to child abuse, negligently causing serious bodily injury attempt, and received 2 years community corrections and 369 days credit for time served.
So as I indicated before, since the March 2nd meeting, almost daily we are uncovering new examples of crazy dismissals and plea deals. In all honesty, our community partners from across the valley are bringing information to us because they are desperate for this information to be brought out to the public. It's clear that this is not just a problem for Alamosa. This is a problem for the entire valley. And as I indicated when we first started talking tonight, we have a new category, which is a lack of prosecution related to animal cruelty. I am going to share a document, but I do want to provide a warning that the pictures might be disturbing. Is it sharing yet? There we go. So we have a few cases that have been shared with us. And the first one is about an abandoned horse. The Colorado Humane Society was called about a dead horse in Castilla County. When they arrived, they found a horse tied to a tree, left for dead, and it had been there for several months. Upon questioning, the owner admitted to leaving the horse there. After riding the horse down the mountain, neglected and emaciated in chest-deep snow, when the horse would not go any further, the owner finally gave up and tied it to the tree to die. This was not the owner's first experience with animal neglect. The Castilla County Sheriff's Office wanted to press animal cruelty and neglect charges and was working with DA Willett on such things. However, when Payne was elected and the case became his, he dropped all charges. Another example is called Casper the Dog. This is in relation to a case that occurred in Conejos, where the Conejos County Sheriff contacted CHS after receiving a call that a boxer mix had been stuck in a snare trap. The sheriff found the mutilated dog whose body was almost severed in half. He instructed the owner to seek veterinary treatment. After several more visits, they found that the owner had not sought veterinary treatment and that the snare was still embedded around his stomach. There were no charges pressed for this situation. And then we have the situation with the dogs. This occurred of the threat, or the case was a puppy mill with neglected fighting dogs in Castilla County. A sheriff and CHS agent visited the property. They also have video evidence of that visit. They could see several injured and neglected dogs. And for 7 intense hours, the teams rescued starving dogs, injured and sick dogs, aggressive dogs, dogs with no socialization, and dogs in filthy metal cages that were too small in the hot summer heat. They also found 2 deceased dogs on the property. Altogether, they rescued 103 dogs. The owner was charged with 107 felony counts and 1 misdemeanor, including counts of animal cruelty, a count of theft, count for cyber crimes, and a count for violation of probation. DA Payne shockingly decided to drop all charges without explanation, and the case was dismissed. Obviously, as we talk about our concerns related to the district attorney, we need to also talk about the violations of the Victim Rights Act. As of February 9th, the Colorado Crime Victim Advisory Board had received 8 complaints under the VRA. The first 4, for the first time ever, were forwarded to the governor because they found the DA's office was non-compliant. The remaining 4, which came in later, since then, on February 25th, the subcommittee voted that it was substantiated and forwarded those to the Colorado Crime Victim Advisory Board as well. The complaints include not being treated with fairness, respect, and dignity, lack of information related to plea deals and hearings, requests for information being simply ignored, refusals to meet with the victims, and explosive and confrontational behavior.
In addition to these areas, we've also found the office to be non-responsive to communication efforts, dismissive and combative during meetings, and lacking in timely performance of duties. For example, in December, it was brought to my attention that over 20 warrants had been processed, which means 20 different cases with victims that sat on the DA's desk without action for weeks and sometimes longer. These included domestic violence cases, third-degree assaults, second-degree assaults, second-degree forgeries, thefts, secondary burglaries, and felony menacing cases. Such a delay can have serious consequences. As discussed last time, OMS student Jaden Cruz had been bullied at school, and on Friday, October 1st of 2021, he was assaulted by other students. The Alamosa Police Department had the charges to the DA's office that following Monday. The charges sat without action on the DA's desk. On December 21st of 2021, unfortunately, Jaden tragically took his own life. His guardians assert that without that abandonment by the DA's office, Jaden would not have killed himself.
We want to be clear that the excuses and the narrative provided by the district attorney are not relevant, and they do not explain away the actions or lack of actions of his office. The district attorney has said that his office is underfunded and suffers from a big workload. But for the last decade, the district attorney's office has been underfunded, and they have still pursued jail time for more serious crimes. The district attorney has also indicated that staff changes should address the concerns related to the VRA violations. However, these violations have been occurring for over a year. They involve more than just one attorney, including the district attorney himself, and they speak directly to his leadership of the office. I want to be clear that per the Colorado Rules of Professional Conduct, supervising attorneys, such as the DA, are responsible for the conduct of their subordinate attorneys. I also anticipate that the district attorney will attempt to claim that dissatisfaction is based on political differences, i.e. a Democrat versus Republican platform. We know that council represents both political, and I would say 3 political platforms, which is Democrat, Republican, and Independent. And as I've talked to community partners, these concerns cross both platforms. And I've already shared the similarities we have from a philosophical perspective on lower level offenses.
Through Mr. DA Payne's efforts to avoid jail sentences, there's been an increase in the use of the 12th Judicial District Probation Office for more serious offenses. To learn more, I met with the Chief Probation Officer, Bill Goudelet. None of the certified POs carry a sidearm, and as of lately, the new clients being referred to the probation office are too high risk, and it is dangerous for the probation officers who are not equipped, thus putting the lives of the officers more at risk. One might ask, if they're too dangerous for probation officers, then why are the cases being pled down and not utilizing jail?
When we first began looking into this, one of the questions is, what is the role of the judges? And to be honest, the district attorney has tried to dodge his accountability by saying it's okay for these plea deals and dismissals because the judges are approving it. What we've learned is that it's more complicated than that. For a dismissal, all the prosecutor has to show is that there is a legal reason for the dismissal, which more often than not is they cannot prove the case beyond a reasonable doubt, or the victim was not cooperating. Since judges do not have access to the evidence, nor are they privy to any communication with the victims, they have to rely on the word of the prosecutor. It's also similar for the plea deals. We have learned that there may be multiple instances where the district attorney's office has told the court that they have communicated with the victim when in fact they have not. And then just today we received information about a citation for contempt that Eric will cover here briefly.
Yes, counsel. Last week, citation for contempt was filed in Rio Grande County District Court by Judge Amanda Hopkins against DA Payne. Now, a citation for contempt is like a complaint or a pleading, so it's not been proven, but the allegation has been made by Judge Hopkins that DA Payne lied in court to her concerning a reason for dismissal, and in particular had indicated that a case was being dismissed because the victim didn't want to testify. And it turns out when the victim's advocate at the sheriff's office saw the dismissal and called up the court clerk wondering what the heck was going on, that was just not true. And so the citation for contempt has issued. The district attorney, I think, has gained a reputation in the judiciary for not being reliably truthful, which is one of the most serious violations of the rules of professional conduct that an attorney can engage in.
Is it?
I think
the
we're
chief?
back to Chief Anderson.
Thank you, Eric.
Thanks. In District Attorney Payne's own words, overzealous and unwarranted prosecutions have put such a strain on our criminal justice system that it is at a breaking point. I would argue that applying the oversimplified "don't put them in jail" philosophy to all levels of crime is simply irresponsible and contrary to the role of the prosecutor. There is a difference between someone who is shoplifting because of an underlying substance use condition and someone who is distributing pounds of drugs with assault weapons and thousands of dollars in drug money. There is a difference between low-level offenses and murder. There is a difference between low-level offenses and murder. I want you to understand that. Let me put that out there. The inappropriate plea deals have left victims feeling helpless and often re-victimized, and have sent a clear message to those considering breaking the law that the San Luis Valley is a safe haven for criminals. Our officers have literally had arrestees laugh as they're being handcuffed, and I've had to watch this lately as the chief, which is concerning. We put our officers' lives at risk every time they have to make an entry on a narcotic operation or any other critical incident. Our neighborhoods and residents are at risk when criminals are allowed to avoid jail time and walk around our community. Quite honestly, I'm the one that gets these phone calls about this, and I'm running out of responses. I don't know what else to tell them. We're doing what we can. The comments I hear now from residents is at least we have a day of no fear. These are our victims whose voices are being ignored, victims I made a pledge to protect and serve over 20 years ago.
As we shared at the last council meeting, there is a current movement to petition for a recall election. To that point, council has 2 items before you on your agenda tonight. You have the public hearing and second reading for Ordinance 5-2022. This is seen as the umbrella ordinance that allows council to provide funds for local elections. We are changing that language to allow recall efforts to be included as the proper use for those funds. The expenditures are limited to recall elections, not all types of elections. Also, as the city attorney explained before, since this is a valley-wide issue and not necessarily just a local issue, the city can participate up to the point that the Secretary of State certifies the signatures on the petitions as valid. The other item that is before City Council tonight is Resolution 6-2022. So you have your umbrella of an ordinance, and then under that is the resolution that actually authorizes resources for this specific recall election. During the last meeting, there were some questions about whether or not a public entity should participate in a recall election. And I think a little bit more information would help clarify this. The city does not necessarily anticipate spending an actual $10,000. That maximum amount is related not only to the use of physical money, but also the value of staff time and other city resources. So for example, last Saturday, the Recall Payne group held a meeting and it was open to the public. City staff cannot attend something like that in order to share information and find out what's going on until we are authorized per Resolution 6-2022. That's a use of city resources that, if this resolution is passed, allows city staff to participate in those types of activities. Some have wondered if it's an appropriate use of public funds for this effort. And to that, I have some information as well. The first point is just simple math. Every narcotic operation that we conduct, it costs between $1,500 to $2,000. Since we've conducted over 40, that's $80,000 on narcotic operations. If we could have prevented just half of these because the perpetrators were in jail, we could have saved the city $40,000 or 4 times the $10,000 that this resolution is authorizing. My other point, though, is there's no value we can place on the lives of our officers who have been risking their lives every time they enter these situations. The second point I want to make is that the city council, city staff, and especially our police department are charged to protect our residents. Alonzo Payne, as the district attorney, is a direct threat to the safety of our residents. And finally, my last point, if this is a prudent use of public funds, our law enforcement, our own employees who we have a responsibility for, risk their lives when they interact with these criminals. And under this district attorney, their lives are more at risk. And with this, Mayor, I'll turn it back over to you for a public hearing.